The President.
Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation. Announcements by the President.
Honourable Senators, I have granted leave of absence to Senator the Honourable Franklin Cann, Senator the Honourable Alison West, and to Senator Hazel Thompson Aye, all of whom are out of the country, and to Senator Tahaka Obika, who is ill. Honourable Senators, I have received the following correspondence from Her Excellency the President, Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Mr. Ndale Young. Whereas Senator the Honourable Franklin Cann is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Ndale Young, to be temporarily a member of the Senate, with effect from the 2nd of April 2019, and continuing during the absence from Trinidad and Tobago of the said Senator the Honourable Franklin Cann. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President and Annes this first day of April 2019. To Mr. Augustus Thomas, whereas Senator the Honourable Alison West is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago. Now, therefore, I, Paula May Weeks, President as aforesaid, acting in accordance with the advice of the Prime Minister, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Augustus Thomas, to be temporarily a member of the Senate, with effect from the 2nd of April 2019, and continuing during the absence from Trinidad and Tobago of the said Senator, the Honourable Alison West. Given under my hand and the seal of the President of the Republic of Trinidad and Tobago, at the Office of the President and Annes this first day of April 2019. To Karuna J. Bisramsingh. Whereas Senator Tahaka Obika is incapable of performing his duties as a senator by reason of illness. Now, therefore, I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Karuna J. Bisramsingh, to be temporarily a member of the Senate, with effect from the 2nd of April 2019, and continuing during the absence of Senator Tahaka Obika by reason of illness. given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, the 2nd day of April 2019. To Mr. John Heath, whereas Senator Hazel Thompson IE is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Mr. John Heath, to be temporarily a member of the Senate, with effect from the 2nd of April 2019 and continuing during the absence from Trinidad and Tobago of the said Senator Hazel Thompson IE, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President St. Anne's, this 1st day of April 2019. Honourable Senators, senators are required to take the oath.
I, Ndale Young, having been appointed a Member of Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, and will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities of the people of Trinidad and Tobago upon which I am about to enter.
I, Augustus Thomas, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I am about to enter.
I, Karuna Visramsingh, having been appointed a Member of Parliament, do swear by the Bhagavad Gita that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, John Heath, having been appointed a Member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Directors, I have received the following correspondence from the Speaker of the House of Representatives. April the 2nd, 2019. Dear President of the Senate, referral of Income Tax Amendment Bill 2019 to Joint Select Committee. At a sitting held on Friday, March 29, 2019, the House of Representatives agreed to the following resolution. Resolved, that in accordance with Standing Order 64-1C of the House of Representatives, the Income Tax Amendment Bill 2019 be referred to the Joint Select Committee established for the consideration and report on the Mutual Administrative Assistance in Tax Matters Bill 2018 and the Tax Information Exchange Agreements Bill 2018. I respectfully request that the Senate be informed of this decision at the earliest convenience, please. Respectfully, the Honourable Bridget Mary Anissa George, MP, Speaker.
Bills brought from the House of Representatives on the supplemental order paper, the Non-Profit Organizations Bills 2019 in the name of the Attorney General. Petitions, papers.
Minister of Works and Transport.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper in my name. The ministerial response of the Ministry of Works and Transport to the 16th report of the Public Administration and Appropriation Committee, 3rd session, 2017-2018, 11th Parliament, on the examination into the implementation of the Public Sector Investment Program, and the annual administrative report of the Point Lisas Industrial Port Development Corporation Limited for the period January to December 2015. I thank you.
Acting Leader of Government Business.
Madam President, I have the honor to lay on the table the following papers as listed on the order paper and the supplement order paper in the name of the Minister of Finance, the Minister of Tourism, the Minister of State in the Office of the Prime Minister, and the Minister of Public Administration. The ministerial response of the Ministry of Finance to the 16th report of the Public Administration and Appropriations Committee, 3rd session 2017-2018 of the 11th Parliament on an examination into the implementation of the Public Sector Investment Program. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Tunapuna-Piarco Regional Corporation for the years ended September 30th, 2009 and 2010. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Regulated Industries Commission for the year ended December 31st, 2014. The annual audited financial statements of National Quarries Company Limited for the financial year ended September 30th, 2013. The ministerial response of the Ministry of Tourism to the 15th report of the Public Administration and Appropriation Committee, 3rd session 2017-2018 of the 11th Parliament on the examination of the expenditure and internal controls of the Ministry of Tourism. The annual administrative reports of the Ministry of Tourism for the years 2015 and 2017. The annual report of the Children's Authority of Trinidad and Tobago for the period ended September 30th, 2018. And finally, the annual report of the National Information and Communication Technology Company Limited for the year 2016 to 2017. I thank you.
Reports from committees.
Senator Timal.
President, I have the honor to present the following report as listed on the order paper in my name. The 6th report of the Joint Select Committee on Land and Physical Infrastructure, 4th session, 2018-2019. 11th Parliament on an inquiry into the establishment of systems for the maintenance of drainage and roadways. I thank you.
Trade and Industry.
Madam President, I have the honor to present the following report as listed on the order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018. Thank you.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The interim report of the Joint Select Committee appointed to consider and report the Mutual Administrative Assistance in Tax Matters Bill 2018 and the Tax Information Exchange Agreements Bill 2018 in the 4th session 2018-2019 of the 11th Parliament. Thank you.
Urgent questions?
Senator Richards.
Thank you, Madam President. Good afternoon, everyone. To the Minister of Health, can the Honourable Minister indicate how much damage was caused by the fire at the Port of Spain General Hospital on Friday, March 29, 2019?
Minister of Health.
Madam President, in December of 2016, the Ministry of Health directed all RHAs to do a security risk assessment with 8 deliverables, including emergency decanting. Let me say up front, our primary objective is to save lives, and I want to thank the nurses at the Port of Spain General Hospital following our procedures, successfully decanted and safely done so after the earthquake of last September and the fire of Friday. There was no loss of life, no one was injured, and our nurses are to be thanked. As far as damage is concerned, in the ICT department, 4 Mac computers were lost, 2 Mac power cords, 7 Dell Windows desktops, 3 printers, 14 Cisco PBX phones, copper and fiber internal networking. It is difficult to give a price at this point in time because we have to get estimates for replacement. It doesn't make sense to talk about book value of these things. The physical infrastructure, after an examination by the Ministry of Works, the building is structurally sound. However, we will have to replace galvanized roofing, ceilings, desks and chairs, and so on. What is noteworthy is that our 2 ultrasound machines are fully functional and will be relocated by tomorrow to restart ultrasound work. Our container CT is functional, was untouched by the fire. So those services will be up and running. Madam President, I want to thank all the RHAs who gathered and rallied around Northwest on Friday night. Doctors came out, nurses came out, ambulances came out, and all the other RHAs were on hand to take up the slack in case they were needed. Luckily, they were not needed because our nurses, again, performed above the call of duty. Thank you very much.
Thank you, Minister, for the comprehensive response. Can the Minister indicate, given the fact that it was a fire and there would have been soot and smog, if there had been any displacement of patients and or staff?
Minister?
Yes, as I indicated, the nurses had to decant some patients because of smoke. So the answer is yes. We also had some smoke going into the maternity hospital, which is just to the north of that. But thankfully, we were able to get that facility up and running within hours. So neither the NICU was adversely affected, and we thank God for that. And by yesterday, operations as far as patient care were not compromised, and they will return to normal, principally, again, due to the action taken by our nurses, ably supported by the security staff who were on hand at the time. Thank you very much, Madam President.
Senator Richards.
Thank you again, Madam President. Thank you again, Minister. And finally, given your response regarding the ultrasound machines, can the Minister indicate if ultrasound services have been transferred to another unit, or if that is not an issue at this time?
As I indicated, the ultrasound machines were not affected. However, they will be relocated by tomorrow to restart ultrasound services at Port of Spain. In the interim, we would have sent them to Eric Williams if they needed to. Or the entire health system came together as one to lend support to Northwest Regional Health Authority on Friday night, including JMRTT in case we needed extra ambulances. Doctors at Eric Williams were on standby. Everyone was on standby in case the incident escalated. It did not escalate, but I want to express my gratitude to every single healthcare worker across the RHA system. We worked as one, and we mitigated loss. Thank you very much, Madam President.
Senator Mark.
Thank you, Madam President.
Good luck.
To the Minister of Works and Transport, given recent reports that the government intends to lease a ferry to service the Sea Bridge. Can the minister confirm the name of the new ferry, the daily charter rate, the period of the lease, and the name of the supplier?
Minister of Works and Transport.
Madam President, government had indicated its plans to provide vessels for the Inter-Island Sea Bridge. Government proposed 3 time spans to deal with this. There was a short term, which the government indicate that the acquisition of the Galleon Passage, together with TNT Spirit, which resulted in 2 vessels servicing the Sea Bridge. The long-term plan from the government was the acquisition of 2 new fast ferries, which have already been ordered. The medium-term plan from the government was the leasing of a fast ferry to complement the 2 existing ferries for a period of 1 year, which would allow the government to take possession of the 2 new fast ferries. A tender went out in August of 2018. It closed in October of 2018. A recommendation have been made where the preferred tenderer is Virtue Holding. Coming out of that tender where 3 companies produced options. It was an international and local tender. The name of the vessel is the Jean de la Vite, Jean de Lut, and the preferred, the company is Virtue Holdings, and the contract is at this time being finalized by NIDCO, and as soon as that is completed, the figures will be presented to the Senator Mark as requested.
Senator Mark.
Can the minister indicate, Madam President, what type of contract is being envisaged for this lease arrangement? What is the name? What is the type of contract you are anticipating for this lease arrangement?
Minister.
Madam President, let me get the name of the vessel is Jean de Valette and Valette. It's a lease vessel, and I must indicate that the NIDCO did utilize the professional and excellent service of a specialist maritime firm out of the UK to ensure that the contract that is being signed with NIDCO and this company is in keeping with the maritime agreements. And the period of time is for 1 year with the option to renew for a further 6 months if needed. Thank you.
Senator Mark.
Madam President, may I ask the Honourable Minister whether he's aware that this vessel is a defective vessel that was subject to arbitration in England and also court proceedings in Australia. Can you indicate to this Parliament whether you're aware that this vessel is a defective vessel? Can you tell
Minister.
Madam President, I'm not surprised at the question because I expected the opposition to bring fake news and try to damage all the efforts by this government to ensure that we have a better sea bridge. Thank you.
Next question, Senator Mark. And please, members, please lower your voices. Senator Mark.
Thank you very much, Madam President. To the Minister of Energy and Energy Industries. In light of NP's, National Petroleum, that is, admission of an unusually pungent scent of sulfur from the fuel at the pump, can the minister state what measures are being taken to address this situation?
Acting Minister of Energy and Energy Industries.
Thank you, Madam President.
I know.
I'm advised by NP that the batch of fuel they received in March 7 to be exact, was tested for compliance on receipt. The fuel met all the requirements of the certificate of quality. However, it was observed that the fuel did have a pungent odor. NP sought to remove the odor from the gasoline by using a chemical scavenger, which had some effect.
Minister, just 1 second. Honourable Senators, the time for urgent questions has expired, but I will allow the Minister to finish to complete his answer.
Thank you, Madam President. So, NP used a scavenger to remove the odor in the super, but the scavenger is not effective on diesel. So the diesel remains with the odor. Another batch of super gasoline was received on the 2nd of April, today actually, has met the quality standards, does not have the odor, but there would be some residual odor in the fuel that remains within the tanks.
Questions on notice? Questions for oral answer?
Acting Leader of Government Business.
Madam President, the government intends to answer 7 questions. These questions are number 93, number 94, number 137, number 138, 139, 167, and 169. Madam President, the government is asking for referral of number 95, 173, 174, and 175. Thank you.
What about 132?
Questions numbers 95, 173, 174, and 175 are deferred for 2 weeks. 2 weeks?
Madam President.
Yes.
May I ask you to allow us to answer number 95 today? And the deferral would be in respect of 173, 174, and 175 and for 2 weeks. Thank you.
So questions 173, 174, and 175 are deferred for 2 weeks. Senator Mark.
Madam President. Question number 93 to the Minister of Energy and Energy Industries.
Minister of Energy, Acting Minister of Energy and Energy Industries.
The Petrotrin Sports Club and its facilities were closed on December the 3rd, 2018. The building and its facilities are still owned by Petrotrin. The board of Petrotrin is currently looking at commercially viable options for the use of the club and its facilities. However, in addition, the government is examining its options with respect to the utilization in the public interest of Petrotrin assets that are not essential for oil production, and a decision on the way forward will be made shortly.
Senator Mark.
Madam Chair, can the Minister indicate or elaborate on the expression utilization of the assets of these clubs in the public interest? Can you clarify further for us?
Madam President, we in the government recognize that Petrotrin provided quite a large number of services to surrounding communities and also to persons in the surrounding areas. So we are looking at vesting all of the non-essential assets, the non-oil producing assets, into a state enterprise, which would then have control of these assets and would then make determinations as to whether these assets can be made available to the public or whether they would be put up for lease to interested parties, or whether the previous members of the clubs and so on can get involved. The matter is still in its embryonic stage, but we intend to place those assets into another state enterprise which would have the responsibility to manage the non-essential non-oil producing assets of Petrotrin, the former Petrotrin.
Can the Minister indicate what are some of the commercial viable options that are being considered by the government as it relates to the assets of the club, Petrotrin Sports Clubs. Ma'am.
Minister.
As I indicated, Madam President, there are many options, and one of them could be to lease the club and its facilities to former members or other interested parties for their use, or a hybrid approach where the public would also have access to the facilities. As I said, this matter is in its embryonic stage.
Senator Mark.
Can the Honourable Minister indicate whether the government does the government have a time frame or timeline for concluding this particular arrangement as it relates to specifically when would the government come to a definitive conclusion as to the way forward? Is there a time frame for that arrangement?
Thank you, Madam President. Barring unforeseen circumstances, by the middle of this year, 2019.
Okay. Next question, Senator Mark.
Question number 94 to the Minister of Energy and Energy Industries.
Acting Minister of Energy and Energy Industries.
Thank you, Madam President. To date, expressions of interest have been received from 70 interested parties consisting of a wide spectrum of companies in the energy industry. All of these 70 interested parties are eligible to gain access to the data room once they demonstrate that they have the technical and financial capacity to submit a proper proposal and they sign a non-disclosure agreement. The data room will be available until the end of April 2019 to allow preliminary submissions from interested parties, at which time a short list of qualified bidders will be prepared. The date for the submission of final proposals from qualified bidders is June the 15th, 2019. An international investment banker with extensive experience in the industry, namely the Bank of Nova Scotia of Houston, Texas, USA, has been engaged to provide technical advice in the shortlisting and evaluation of proposals for the sale and or lease of the Point-à-Pierre refinery.
Senator Mark.
Yeah. Can the minister make public the names of these 70 interested parties in bidding for the purchase or lease of the Point-à-Pierre refinery?
Minister.
Madam President, that formed no part of the question. The question referred to the experts who will evaluate the outcome of the RFP, so I do not have that information with me. I'm certain if Senator Mark poses that question in the normal manner, that the information will be provided.
Senator Mark.
Can the Honourable Minister indicate how the Bank of Nova Scotia International was chosen or selected to conduct technical studies into these various proposals that are coming before the government?
Minister.
Madam President, I don't have the precise details, but I want to repeat that this company, this international investment banker, has extensive experience in the industry, but I don't have the details of the procurement process. That too will be answered if a question is posed.
Senator Mark.
Could the minister indicate whether the former managing director of Scotia Bank, Richard Young, was involved in recommending this particular institution for consideration?
That question is not allowed. You have one more question, Senator Mark.
All right. Can I ask the Honourable Minister, where exactly, Madam President, is this data room located?
Minister.
At the former Petrotrin.
Next question, Senator Mark.
What do you think it is?
Question number 95 to the Minister of Energy and Energy Industries.
Acting Minister of Energy and Energy Industries.
Thank you, Madam President. The Augustus Long Hospital was decommissioned effective November the 30th, 2018. The hospital has not been sold or leased to date. However, a request for proposals is being prepared and will be issued within the next few months for the lease and/or sale of the Augustus Long Hospital.
Senator Mark.
Can the minister indicate why it has taken so long for a very important institution and healthcare facility to go out via request for proposals? Why has it taken so long, Madam President, having regard to the fact it was decommissioned since November the 30th, 2018? Can the minister advise?
Minister.
Madam Speaker, a hospital is not a parlor or a rum shop. It requires considerable thought. It's a complex matter. I do not agree that this is a long time.
Senator Mark.
I'm conscious it is a parlor or a shop.
And Senator Mark, I am conscious that you're asking a question. So well, could you ask the question, please?
Yes, I am getting to there now. Can I ask the Honourable Minister through you, Madam President, whether he's aware that close to $2 million worth of vital pharmaceutical products and drugs used by patients and doctors have been lost. Lost meaning, Madam President, they have expired and therefore would be of no use to anyone. Is the minister aware of such value in terms of the pharmaceutical products?
Minister.
Madam President, that is fake news.
Senator Mark.
Can the minister indicate whether the Minister of Planning and Development, in answer to a question in the other place, was providing the country when the minister indicated some $1.5 million was lost by expired drugs or through expired drugs? Was the minister engaging in the spreading of fake news when that statement was made?
Senator Mark, I won't allow that question. You have one more.
You've got to be kidding me, man.
Yeah. Madam President, I'll go on to the next one.
Sure.
Madam President, with your leave, I would like to ask the remaining questions in the name of Senator Obika. I'd like to ask those questions.
Sure. So, yes. Yes, of course.
Yes, Madam President. Question number 132.
No, not 132.
Oh, I beg your pardon.
That's fine.
My apologies. Question number 137 to the Minister of Finance.
Minister of Finance.
None.
Can the minister indicate whether it was fake news when the Caribbean Airlines took out full-page advertisements throughout the industry, advertising and boasting that it had realized dividends or profits, I should say, during that period?
Minister.
Madam President, I don't know why Senator Mark says these things. Caribbean Airlines declared a profit for part of its financial year. You have to wait until the financial year is over, and then the auditors have to come in and determine whether any dividends will be due to the state.
Can I ask the Honourable Minister, seeing that we're talking about 2016, 2017, and 2018, when will the auditors be visiting the compound of Caribbean Airlines to determine whether dividends will be paid to shareholders, which is the government of TNT? Can the minister indicate, sir?
Minister of Finance.
Thank you, Madam President. Let me just repeat this question. The amount of dividends collected from Caribbean Airlines during the period 2016 to 2018. As far as I'm aware, 2018 ended in December. And the answer to that question, the amount of dividends collected, is none. So I've answered the question.
Senator Mark.
The question asked during the period.
Well, I don't think, Senator Mark, I don't think that we need to be reading and rereading the question. The minister has given a response. You are entitled to ask a question now, but don't reread the question, please.
Can I proceed, ma'am?
Yes.
Because I don't want to engage in fake news.
You don't want to, you sure?
No, you are the...
Senator Mark, Senator Mark, please.
Madam President, may I face you?
You should.
Okay. I cannot...
Senator Mark?
Madam President.
Yes?
Madam President, may I ask question number 138 to the Minister of Sport and Youth Affairs.
Acting Leader of Government Business.
Thank you very much, Madam President. I answer this question on behalf of the government. Madam President, construction of the Couva Aquatic Center was completed in 2016, and the Sport Company of Trinidad and Tobago was engaged by the Ministry of Sport and Youth Affairs to operate and manage the facility post-construction. The facility successfully hosted the Caribbean Swimming Championships in 2017. Madam President, the Sport Company has advised that the total revenue earned from the Couva Aquatic Center for the period 2016 to 2018 was $167,455.12, detailed as follows. Total revenue received in fiscal 2017-2018 was $135,905.62, and total revenue in fiscal years 2018 to 2019 up to December 31st, 2018 was $31,549.50. Thank you.
Chair, Madam President, can the Minister indicate whether the government is satisfied with the marketing thrust by the Sports Company of Trinidad and Tobago in promoting the excellent first-class facilities, all provided by a United National Congress government, is being conducted or is being prosecuted or promoted? Is the government satisfied?
Madam President, having regard to the question, I'm not in a position to indicate whether or not the government is so satisfied.
Senator Mark?
Can the Honourable Minister indicate whether any major events aimed at generating further revenues for the people of Trinidad and Tobago will be addressed in the coming period? Can you share with this Honourable Senate?
Senator Mark, that question does not arise. Next question.
I will go on.
Yes?
I go on to the Real Minister now. The question number 139 to the Minister of Agriculture, Lands and Fisheries.
Minister of Agriculture, Lands and Fisheries.
Thank you very much, Madam President, and I thank Senator Obika and Senator Mark for the question. Madam President, as of December 2018, certain positions in NAMDEVCO, such as marketing positions, were vacant for a number of reasons, including the expiration of contracts and persons moving on to other jobs elsewhere. The Board of NAMDEVCO subsequently conducted a review of its organizational structure and manpower needs before proceeding to fill the vacancies. At this time, Madam President, the position of Manager Market Facilitation is being advertised, and over time, other positions will also be advertised. I thank you.
Senator Mark?
Can the Honourable Minister share with us, based on the manpower audit and restructuring, can the Minister indicate how many positions have been created in this particular department or section of NAMDEVCO? How many?
Minister.
I know one has been advertised.
Minister.
Madam President, I'm not in a position to indicate at this time how many have been created. And in relation to this position, I can say that this is a position that had existed before. So it's not a new position.
Senator Mark?
Would the Minister be in a position to supply to this Honourable Senate the organizational structure of NAMDEVCO, particularly in the area as identified, so the Senate would be better apprised?
Certainly, Madam
Minister.
President.
Can the Minister indicate to this Honourable Senate when he would be able to do same?
Minister.
Madam President, I'll do that by the next sit-in, which is April 9th, 2019. Thank you.
Thank you, Madam.
Next question, Senator Hussain.
Thank you very much. Thank you very much, Madam President. Question number 167 to the Acting Minister of Energy and Energy Industries.
Acting Minister of Energy and Energy Industries.
Thank you, Madam President. Answer to part one. The net loss for the period December 1st, 2018 to January the 31st, 2019 for Heritage Petroleum during the period of startup operations was US $2.76 million. It should be noted that the loss incurred by the former Petrotrin for a similar 2-month period was as much as US $50 million. Answer to part two. The net profit for the period December 1st, 2018 to January 31st, 2019 for the Paria Fuel Trading Company was TT $46.1 million.
Senator Hussain.
Question asked, I heard the Minister said net loss when you answered the question. The question asked for the net profit of the Heritage Petroleum Company. I heard that you said net loss.
Minister.
Madam President, I'm confused. The question asked what was the net profit. I said one company made a loss, one company made a profit. The first company made a loss of $2.76 million US. The second one made a profit of $46.1 million. What more do I say?
Senator Hussain. Senator Ramdeen.
Thank you, Madam President. Good afternoon, Madam President. Thank you to the Honourable Minister for the answer. Honourable Minister, Madam President, through you to the Honourable Minister, could the Honourable Minister indicate to the Senate whether, when the Heritage Petroleum Company was formed, it was foreseen by the government and the board that it would incur a loss at the outset?
Minister.
Any company of that nature that is taking over a massive operation like that would have some teething problems. I would expect as we move along, the company will move from this very small loss, which is a fraction of what it used to be, into profitability.
Senator Ramdeen.
Thank you, Madam President. And Madam President, through you to the Honourable Minister. Honourable Minister, when do you expect that the Heritage Petroleum Company will begin to earn this profit that you foresee will come in sometime in the future?
Minister.
I would think within the first financial year.
Next question, Senator Hussain.
Question 169 to the Acting Minister of Energy and Energy Industries.
Acting Minister of Energy and Energy Industries.
Thank you, Madam President. The active companies that arose out of the restructuring of Petrotrin, namely Heritage Petroleum Company Limited and Paria Fuel Trading Company Limited, are focusing on implementing sustainable commercial operations. Accordingly, the government is looking at its options for continuation of an appropriate corporate social program for the groups, clubs, and activities previously sponsored by Petrotrin, and the way forward will be made public in the near future.
Senator Hussain.
Madam President, can the Minister indicate when this will be done?
Well, Senator Hussain, I think the answer gave a certain
Understood. I'll ask another question.
Yes.
Madam President, can the Minister indicate how many of these clubs, or groups are affected by the decision in terms of the closure of Petrotrin and their social corporate responsibility?
No, Senator Hussain, that question does not arise. Senator Ramdeen.
Thank you, Madam President. Madam President, through you to the Honourable Minister. Honourable Minister, when the decision was taken to close the Petrotrin refinery, having regard to the dependency of these groups and clubs on the former Petrotrin for their sustainability, was any contingency plan contemplated or put in place by the government having regard to the fact that these groups depended on Petrotrin for their sustainability?
Minister.
Indicated in answer to another question, the government has decided to give this responsibility among the responsibility of other things, such as the responsibility for the clubs, the recreation grounds, and so on, to another state enterprise. That has always been part of the plan, and that is in formation as we speak.
Acting Leader of Government Business, there are questions that are for written answer. Are you in a position to provide an update?
Madam President, I'm not in a position now. You allow me to provide the update later in the sitting? Thank you.
Motions relating to the business or sittings of the Senate and moved by Minister.
Acting Leader of Government Business.
Madam President, having regard to the interim report of the Joint Select Committee established to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018, I beg to move that the committee be granted an extension of time to May 31st, 2019 to complete its work and submit a final report. Thank you.
Honourable Senators. The question is that the Joint Select Committee appointed to consider and report on the National Statistical Institute of Trinidad and Tobago Bill 2018 be granted an extension of time to May 31st, 2019 to complete its work and submit a final report. Those in favour say aye.
Aye.
Those against say no. I think the ayes have it. Acting Leader of Government Business.
Madam President, having regard to the correspondence from the Speaker of the House, I beg to move that the Senate concur with the House of Representatives and that the Income Tax Amendment Bill 2019 be referred to the Joint Select Committee established for the consideration and report on the Mutual Administrative Assistance in Tax Matters Bill 2018 and the Tax Information Exchange Agreements Bill 2018. Thank you.
Honourable Senators, the question is that the Senate concur with the House of Representatives and that the Income Tax Amendment Bill 2019 be referred to the Joint Select Committee established for the consideration and report on the Mutual Administrative Assistance in Tax Matters Bill 2018 and the Tax Information Exchange Agreements Bill 2018. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Acting Leader of Government Business.
Thank you, Madam President. Madam President, having regard to the interim report of the Joint Select Committee appointed to consider and report on the Mutual Administrative Assistance in Tax Matters Bill 2018 and the Tax Information Exchange Agreements Bill 2018, I beg to move that the committee be granted an extension of time to May 31st, 2019 to complete its work and submit a final report. Thank you.
Honourable Senators, the question is that the Joint Select Committee appointed to consider and report on the Mutual Administrative Assistance in Tax Matters Bill 2018 and the Tax Information Exchange Agreements Bill 2018 be granted an extension of time to May 31st, 2019 to complete its work and submit a final report. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Business bills, second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that an act to amend the Evidence Act, Chapter 702, be now read a second time. Madam President, the work before this Parliament today really is of significant moment, significant measure. One of the strongest arguments as to the level of sophistication and worth of a society is whether a society is truly and genuinely in a condition where life and liberty of its citizens are properly accounted for by the state being seen and being believed and being felt to be in a position to provide safety for its citizens. Crime is the #1 issue in this country and has been for a very long time. It is the thing, that confidence that is associated with whether crime is being managed or not, that really allows us the freedom and privilege to enjoy our lives. We long for burglar proofing to be removed from our windows. We long for detection to be met with by conviction after prosecution with due process in the courts of law. We long for that gap between detection and conviction to be as short as possible. We hope that that drives a deterrent effect into those who would otherwise consider unlawful purpose. Now, we as a country have a number of issues in the system to address. The pace of the criminal justice system, but there comes a point in our consideration as to laws which fit into the criminal justice system where we have to really analyze whether law transforms society or whether it is society that transforms law. And this bill today is about that, Madam President. Time and time again, and Senator Ramdeen in particular has very often pointed out to the fact that it is the core function of witnesses coming forward in the criminal justice system that really takes us to that whole dance as to whether we have conviction following prosecution, which followed identification and detection. And very often we have this argument about putting in money behind the witness protection program. We talk about whether judges are available. We talk about whether prosecutors are available. We talk about whether defense attorneys are available. But at the end of the day, the government forms the view that an essential part of adjustment in the system has to be the manner in which evidence relates to significant issues such as witnesses. So the Evidence Act is before us. We propose to amend it. The Evidence Act, Chapter 702, is an Act of Parliament number 4 of 1848. If we amend this law today, it will be the 30th amendment to the law. That law now stands at 171 years old. The common law, as we inherited it, the laws of England on the statutes as we inherited it, as stood in our 1962 Constitution and then our 1976 Constitution as we received law, that law of evidence has taken a process of time. We went through the European inquisitorial system. We went through certain procedures that applied there. We then went into the fairness and positions. But what we do know is that our Constitution of the Republic of Trinidad and Tobago, our 1976 Constitution, at Section 5 says there is to be protection of rights and freedoms. And in particular, 5F says, without prejudice to subsection 1, subsection 2 says, but subject to chapter and to section 54, Parliament may not deprive a person charged with a criminal offense of the right, 1, to be presumed innocent until proven guilty according to law, but this shall not invalidate a law by reason only that the law imposes on such person the burden of proving particular facts, and 2, very importantly, to a fair and public hearing by an independent and impartial tribunal, or 3, to reasonable bail without just cause. There is, of course, the enshrined privilege, right, golden rule that you're innocent until proven guilty, but our Constitution has established rights. And this concept of due process and fairness and public trial sits within the confines of this law. So we come with this evidence bill. We essentially seek to do 6 things. The 6 things which we seek to do is contemplated in amendments to the Evidence Act itself. We propose that there are regulations which ought to follow. We have in fact drafted those regulations already. They're not before us now, but I can tell you the regulations in fact went out in stakeholder comment along with the bill. We drafted this law. We have been in the position where the Evidence Act was in active consideration, certainly by two successive governments. Under the UNC government in 2013, the Ministry of Justice considered certain important reforms. Regrettably, the work was not crystallized after some of the work was done by the Ministry of Justice. And then under this government, we certainly took the approach to amend the Evidence Act and produce new regulations. We have been out in public consultation squarely for 2 years, but importantly, by way of written correspondence, by way of engagement with stakeholders. Since September 2018, we have been writing to all stakeholders and asking for comments. We have, in fact, received commentary coming back from certain of the stakeholder positions. We got commentary coming back from the Trinidad and Tobago Police Service, from the judiciary. Unfortunately, notwithstanding 1, 2, 3, 4, 5 written correspondence requests of the Law Association and several telephone calls, we have had no correspondence or commentary from the Law Association, nor have we had from the Criminal Bar Association. And we have also not had any commentary coming from the DPP's office. We wrote many letters, we recorded the position, we invited persons to the table, but we have not had that stakeholder feedback. We engaged, Madam President, the British High Commission. We engaged the Criminal Justice Advisor, who has sat in a rotational position since the last 7 years, certainly in this country. And we sat down and we drafted laws which now find ourselves, which we now find before us here as a Senate. I was saying that we're seeking to do 6 things ultimately in this bill. Number 1, we're seeking to treat with the identification of suspects, and in particular, in the identification mechanisms that we're treating with in Division 2, which is set out in clauses, in Clause 4, in sub-clauses 12A to 12B, the new sections that we propose, that is sections 12A to 12P. We ask for a formalization of the standing orders which the police have been using. Let me explain that. Currently, the method of identification of suspects involves a number of methods. That methodology is, in fact, something which has been published in the laws of Trinidad and Tobago via standing orders of the Trinidad and Tobago Police Service. The standing orders were first published under the old legislation, under the regulations there, under Section 57(1)A. In 2007, there was a republication of standing orders pursuant to Section 193(1)A, and those standing orders, and in particular Standing Order 29 of the TTPS, is the method by which we say you ought to identify people, what procedure is to be followed, what priorities to be adopted, in what circumstances that is to be done. But that is subsidiary legislation. Today, we step forward quite simply and we say, let us take the subsidiary legislation, which has stood in standing orders, let us marry it with best practice, and the best practice that we've taken is in fact coming out of the United Kingdom experience, Code D, the revised Code of Practice for Identification of Persons by Police Officers. That comes out of the PACE reforms. It is updated as at February 2017. We take that subsidiary law, we bring it into the primary law for the first time in a prescriptive format. We put it into the Evidence Act, and we say that all methods of identification and the priorities of identification are to be treated within primary law. We do that for the legitimate aim that there is too much mischief in the inconsistent application of the standing orders. So one of the things that we do by way of legitimate aim, and the first purpose of this bill in treating with identification, is we say, lift out of the subsidiary law, bring it into parent law, so that we balance with precision the rights of the accused versus the processes of the prosecutorial and investigative arms. And we say that that is a mischief to be cured by parent legislation. The second thing which we do is we specify into parent law the electronic recording of interviews of suspects. And I'd like to say we do that in the new section hailed as Division 3 in sections proposed by this bill, clauses 12Q to 12.7, beginning at page 21 of the bill. And in taking electronic recording of interviews of suspects, we are proposing that Trinidad and Tobago adopt a more certain and transparent process where if you're going to interview a person, you have to record that as a best practice in circumstances where it is available. I can tell honorable senators right now that the TTPS has 20 rooms equipped with audio-visual recording capabilities for interviewing persons. They do, in fact, conduct audio-video recorded interviews. At the Aruca police station, they're equipped with 2, and the Riverside building with 3, alongside their names stated below. And then we have 17 particular divisions: Piarco, Arima, Aruca, Maruga, Maloney, Kumuto, Oropouche, Maracas, Belmont, Labre, Brasso, Sangre Grande, ACIB at Riverside, Riverside 2nd Suite, Gasparillo, Maraval, Shirvan Road. These 17 locations have, in the spread of positions, 20 audiovisual recording suites. Why? One of the significant arguments that step forward from time to time is that that statement was not mine. That written statement before a justice of the peace who works for the state, I was beaten into submission to sign that statement, and then there is a recanting of the statement. One has a better chance of seeing whether there was coercion on the part of the investigating officer against the accused if that statement is recorded. Now, the use of audiovisual equipment is not new. The Evidence Act and the regulations that are associated with it provide for the use of suites, etc. There is subsidiary legislation. We are proposing as the second purpose of this law that we lift that out of subsidiary legislation, we lift it out of standing orders, and we put it into the parent law as a mechanism to preserve the best form of evidence in certain circumstances with strict procedures to treat with the interview and the recording of witness evidence. The next thing that we do is we provide, as a third objective, the provision of special measures to allow the testimony of vulnerable witnesses without their security or identity becoming compromised. That is to be found in the new division it's under Division 3, in the new subsections beginning with Section 12AA. And this, Madam President, is not something which is unique. We have already in the laws of Trinidad and Tobago, we already have precedent as to the use of special procedures for certain types of circumstances to be treated with. In particular, as we talk about offenses under the Sexual Offences Act, Section 31E, we deal with the Children's Act. We look at Sections 19A, 19B. We look then further at the Evidence Act, this one, Section 15I, subclauses 1E to H. And in these sections, we provide for, the existing law provides for circumstances where there's a sexual matter, where we're dealing with children, where we're dealing with certain aspects of vulnerability. We allow for the utilization of screens. We allow for the separation of the accused from the person who is vulnerable. We allow for the use of video evidence. We allow for them not to come into contact with each other. So the existing law provides for special measures to allow for testimony of vulnerable witnesses. But what we do in this bill is we go much further, and I'll come to those particulars in a little while. We say to people who are in the concept of the best administration of justice, with the balance of the rights of the accused in mind, with the need for a fair trial, with the understanding of the common law and constitutional prescriptions of Trinidad and Tobago, we say leave it up to a judge, because there may be circumstances where people are fearful of giving evidence, and it is warranting, therefore, of a special procedure to protect that witness. How often we hear the cry, I'm not giving any evidence because I'm fearful of giving evidence. The fourth objective in terms of broad analysis, Madam President, what time do I end in full time?
You end at 10 minutes past 3.
Much obliged. The length of time for this debate does not permit the depth that is required on a bill like this, most respectfully. So I'm trying to give the broadest understanding through you, Madam President, not only to senators, but to the listening public. The fourth area that I was speaking to is the appearance of or receiving of evidence from persons before the court in criminal proceedings by use of video link. What we're doing in this particular fourth objective, we're harmonizing something which exists already in the civil proceedings rules, where you can actually have video link testimony. The criminal law is not specific as to the use of video testimony, but in anticipation of launching the video remand courtyard facility, that is where persons who are incarcerated and not out on bail and who are remanded in pre-trial detention at our prisons can appear before the court by video link. Why do we do that? It's common sense. Number one, we harmonize the civil law. Number two, as a country, to transport prisoners back and forth from the jails, to do remanding, etc., we spend approximately $80 million a year in prisoner transport. And putting one remand courtyard facility, video link, at Golden Grove, at maximum security, wherever it may be, allows us to cut taxpayer expenditure in sensible fashion. Very importantly, the fifth objective is something which I consider to be of landmine nuclear importance, which is certainly something that we're going to have to consider in a 3/5 majority constitutional perspective, and that is the ability to have a witness anonymity order. If there is the most important provision in this law, it is that particular fifth objective. Yes, it is something that does intrude upon established and enshrined rights in the Constitution, but it is not something that is unique in that there are umpteen jurisdictions in the world, and I will traverse those shortly, which have the use of anonymous witness evidence. Anonymous witness evidence, broadened on the concept of vulnerable witnesses, is something which the European Court of Human Rights has treated. It is something which courts in New Zealand, in Australia, in a number of other jurisdictions in the Commonwealth have treated with. The United Kingdom has certainly treated with it. Northern Ireland has treated with it. There's been the flirtation to go there and back by way of common law development, but that was resisted by the House of Lords and Privy Council in particular when you get to the case law and saying, look, let Parliament treat with that. This particular provision allows for people who are fearful of giving evidence to provide evidence without being known, where their names are not known, where their faces are not seen, where their voices are modulated in certain prescribed circumstances, such as to preserve the right to a fair hearing, ultimately with judicial discretion. If ever there was a cry for a clause to treat with this, it has been made in Trinidad and Tobago. Because everybody knows something, saw something, wants to say something. Usually the evidence comes immediately after somebody is dead, where you know of a criminal, and you say, hey boy, everybody know long time that man is a bandit, or a gang leader, or a murderer. Evidence comes flushed out after the death of the accused, albeit now post-mortem, but nobody's willing to step forward because why? Senator Ramdeen has spoken about it, I've spoken about it. Witness protection and the witness protection program is a seriously expensive and inefficient exercise globally, but also in Trinidad and Tobago. The other objective, the sixth objective, is another nuclear provision. The utilization of CCTV footage. The government is engaged in an active campaign, and this is to be found in the new section 12AI at page 35 of the bill. The utilization of CCTV footage ties in with the government's active and aggressive campaign of something called Eyes Everywhere. We all see on our phones CCTV footage of motor vehicle accidents, of murder, of robbery, of attacks. But our laws don't permit the utilization of evidence from CCTV footage. And if you're putting out a safe city, if you're putting out eyes everywhere, if you're putting out the use of cameras to capture by way of technology, number plates and other aspects, you have to harmonize the laws to treat with CCTV evidence. And so this law, this bill before us, proposes to treat with some of that. So let's get into some of the particular positions. I stick a pin for a moment. I ask you to note that statistically, and I've put this before, the government has put this before on umpteen occasions, coming from the judiciary's report, if we looked at the data-driven analysis and therefore the proportionality in addressing a legitimate aim in legislation, we have indictable matters pending at the court. There are 43,109 as of July 31st, 2018. 140,000 road traffic matters at the magistracy. We look to criminal offences pending at the High Court as of July 31st, 2018, which was the last area of identification, the last date, 2006 matters pending. Indictments filed for the year 2017 to 2018, 324, etc., etc. Number of criminal offences in the magistrates' court, 165,154. If we continue to tackle numbers that look like this without thinking outside of the box, then we are going to be exercising the definition of insanity in looking for a different result whilst doing things the same way. It's very important to say, Madam President, that Trinidad and Tobago is at a crossroads. And when we come down to the fact that as a Senate, as a country, as a government, we have had significant reforms to the criminal justice system. I was very pleased to see Senator Choate appear in the newspapers recently as somebody participating in a judge-alone trial, something which this Senate passed into law. We've seen the first acquittal for a murder in a judge-only trial, something which we were told could never happen in the country. We have seen the introduction of plea bargaining, access to bail, divisions of court, the criminal proceedings rules, a public defender system being birthed as we speak, an increase in prosecutorial capacity, an increase in judicial complement. All of these things tie into the amelioration of the system to treat with that kind of numerical load that I've just reminded us of. But when we come down to the law of evidence, it is the law of evidence that is most critical to be managed. So let's go to the bill in a little deeper form. The bill, Madam President, is in the 6 parts that I've divided them into. As we get to Clause 1, of course, is the Evidence Amendment Act, short title. Clause 2, and Clause 1 says that the Act comes into effect on such date as the President may by proclamation put in. So it's intended that there will have to be some tilling of the soil and public education and preparedness into this foray that we are advancing here. The Act shall have effect even though inconsistent with Sections 4 and 5. Yes, we're tripping the rights that I have identified, certainly in respect of Section 5. That comes about in the anonymous witness evidence rules that we'll come to, and I'll come to the constitutionality in a moment. But when we get to Clause 3 does a very interesting thing. It includes an interpretation section to the Evidence Act for the first time. And I would like to say Clause 3, in effect, is going to repeal, via Clause 5, Section 14 of the Evidence Act, Section 14, Subclause 1. Why are we putting it in an interpretation section? We're putting it in to make sure that the use of the terms document and statement can survive by way of application to the entire Act. Why? In serious, complex fraud matters where you have terabytes of information, hundreds of thousands of documents to be put before the court, the admissibility of computer evidence and the admissibility of documents as computer evidence stands becomes a real matter. We've seen the stories where the court takes 4 or 5 days to read out the charges alone to someone because of archaic principles that the charges must be read aloud, etc. But when we're dealing with the admissibility of documentation in major fraud matters as are at the cusp of the commencement of prosecution in this country, and I won't say much more than that, but there's some very old matters at the cusp of prosecution, this becomes necessary. If we get to Clause 4 is where we go into the other 4 purposes that I've identified, where we're coming through the identification procedures, the electronic recording of interviews, the special measures, the use of video link, the witness anonymity aspects, and then the CCTV. It's all of those, sorry, forgive me, the 5 matters envelope there. So Clause 4 is the lion's share of amendments. In Clause 4, when we introduce into the Act a new Part 1A, we call it the police and criminal evidence, and then we go through the creation of divisions, and we put out 3 divisions. First, there's the general division, which is the definitional aspects that I've just referred to for the reasons that I have. We have taken in this the opportunity to harmonize laws which we have introduced elsewhere. We've taken definitions from the Children's Act. We've taken definitions from the regulations, for instance, master copy, etc., in the existing law. Very importantly, we have broadened the definition of police officer. And you will see in the definition of police officer that we have introduced the fact that a police officer includes a special reserve policeman. Why? The Commissioner of Police has already publicly stated that in the reform of the prosecutorial arm of the police, that specialist investigators, let me underline this, specialist investigators, including forensic accountants and lawyers from other jurisdictions, will be admitted to the Trinidad and Tobago Police Service as policemen, as special reserve policemen. Why? Because the admissibility of evidence is an easier task via a policeman than an expert talking through a policeman who does not understand the subject matter. So when you take 36 forensic accountants, as the number now stands, coming into the TTPS to lead evidence as policemen, you are changing Trinidad and Tobago in a fundamental way that has never happened before. And may I underline, Madam President, that is why this Attorney General's office ensured that the Anti-Corruption Investigation Bureau had no place with an Attorney General having a connection to that. Because in our view, we felt that it was improper for a politician to be involved in the police work of Anti-Corruption Investigation Bureau management. And that will make sense soon enough. Madam Speaker, Madam President, the identification provisions in Division 2, which is sections, the new proposed sections 12A go forward, I'll put it in summary point. We provide an hierarchical approach to witnesses being identified, to suspects being identified by witnesses. We go through the standard existing procedures as appear in Standing Order 29 and as improved by Code D of the Revised Code of Practice for Identification of Persons, which is the PACE legislation up to 2017. We then go through the need to have a first description. We provide the number of photographs. We give the particulars as to how that is to be managed, how you present photograph evidence, when and in what circumstances an investigating and identification officer is to be involved, somebody who's not involved in the process but supervises the watching and recording of all of these approaches to suspect identification. We go through the types of investigation procedures, and very importantly in the new proposed 12E as an echo, we deal with the priority. The priority is identification using video medium. Then next, identification in accordance with an identification parade. Identification next in a public place with consent of the suspect. Identification in a public place without consent of the process of the suspect. Identification by confrontation. Now I know that Trinidad does not have a well-developed maturity as it relates between certain matters, between prosecutorial aspects and defense aspects. I'm aware of that. This methodology for the introduction of a priority and circumstance, where you have an investigating officer, an identification officer who's a neutral party, the recording of consent, the recording of lack of consent, the reasons, the process of specifying that you must hand it over to the suspect, that the suspect must be represented. If not represented, that the suspect must have a JP certify the positions. These particulars put out in particular form here now allow us in the specified identification to grow the practice up to where it ought to be. It is entirely unsatisfactory in the domain that it lies right now, standing or sitting. Madam President, we go into the rights of the consent, the rights of the accused in providing consent and caution. We see that in the new proposed section 12F. We deal with the suspect having a representative in the new 12G. We then deal with the suspect not having a representative, the circumstances that prevail there, the cautions that should happen in 12H, etc. And then we go into the eyewitness to be informed and the procedures and cautions there in the new 12I, identification using video medium, etc. And the one that I know causes great concern is the identification parade and the confrontation approach to identification. You can see that in the new 12K and 12L. And here it is, I know, that the practice needs to mature, it needs to be certain, but we suggest and we certainly are advocates of the fact that this particular approach, this specified prescriptive approach in parent law, is the manner in which we get there. Madam President, the identification by confrontation, which is the one that the police most often run to first because they don't discipline themselves to go through the other mechanisms that the court really says ought not to be approached first. Identification by confrontation is in the new section 12O, and that one is the one that I know takes the massaging to get right. But this law provides the methodology by which there must be certification, and more than just pretending they can't find witnesses on the outside, they look for somebody. There's no incentive to get somebody that resembles a witness stepping forward. So when a suspect comes out, and the identification is meant to be that you get people that look, assuming it is me, that people who look like me or sound same height, same racial background, similar form of dress, etc. Where do you find these people? How do you get them to stand on the parade? What is the incentive to get them there? Those are real issues in our society that the police quite often skip over and go directly to confrontation, which is not the most ideal of circumstances. In Division 3, this is beginning in the new section 12Q, we deal with interviews and oral admissions, etc. But I would like to say that if you read this bill, it is just as straightforward as you can get. It is very prescriptive, it is very detailed, and there is precedent. I'd like to jump in because there are only 10 minutes left of presentation time. I'd like to jump into Division 4, and this is at page 28 of the bill, Special Measures Evidence by Video Link and Witness Anonymity Orders. Effectively, Madam President, we have proposed new 12AA, 12AB, 12AC, 12AD, AE, AF. And when we get to AG, with the grant of the witness anonymity order, right down to 12AH, this particular aspect of it is one that is not only novel, but quite controversial. And I'd like to tell honorable members that the UK House of Lords in 2008, in the case of R.V. Davis, and I'm sure my colleagues have read this, those who have access to the laws, R.V. Davis gives a phenomenal overview of the insistence by the British House of Lords that they would stay away from the development of the common law to whittling away the practice of the right to face your accuser in open court. We in common law systems grew up in the English concept, stepping away from the 1600 experiment where we were dealing with special courts and the Star Chamber, etc. We stepped away from those processes, and it's been a golden aspect of our law that, look, you have the right to face your accuser. You want to test the credibility of your accuser. Very different from the inquisitorial system on the European continent. But this case, if ever you had time to read the history of the development of this law, R.V. Davis is perhaps the locus classicus in treating with this. But in the end result, R.V. Davis simply says, this is a matter for the Parliament. And what I can say is that the UK response to this was that Davis basically struck down a murder conviction on the back of evidence which involved persons being anonymous witnesses. The House of Lords struck down the two courts before it and said, listen, this was a dangerous thing to be done. Let the Parliament treat with it. They went through the traversing of rights. But what they did say resulted in an amendment to the English law, firstly by way of a sunset provision in the Criminal Evidence Witness Anonymity Act of 2008. And then after further consideration, it found itself into Part 3 of the Coroners and Justice Act 2009 of the UK. So we've had 10 years of UK consideration of this law, 10 years of European Court of Human Rights on this law, and we have also had umpteen years in treating with this law from a number of other jurisdictions, Madam President. And in particular, I refer to New Zealand, I refer to Australia, etc. And there is an ample amount of learning to be found in the Blackstone's fulminations and publications. So this concept of the use of an anonymous witness order has been well traversed for over 10 years. Now, in the context of the bill, I think it important to put out that the anonymous witness order, which we see popping up, is something which is very much a balancing of rights. The judge, in being invited in the Trinidad and Tobago context, first of all, we don't allow these procedures only for defendants. Sorry, for witnesses. We've said a party. We've left it broad enough to say that if you look to 12AA, subject to subsection 2, in any criminal proceedings, the court may, on an application made by party to the proceedings or on its own motion, issue a direction that a special measure or a combination of special measures shall be used for the giving of evidence. And we treat with the witness vulnerability because we're treating specifically, and what I mean by this, we're treating with the case of child offenders as well, and how we manage these positions. But very importantly, we define in 12AA subsection 3 who is a vulnerable witness. And it means a witness whose ability to give evidence or quality of evidence is likely to be affected by reason of age or immaturity of the witness, physical disability or mental disorder, any trauma suffered by the witness, the fear of intimidation of the witness, or the witness being a virtual complainant in the proceedings for a sexual offense. We allow the court to go through closed proceedings. We allow the court to screen a witness. We allow the court to use video link so that the witness is not present in court and can do so remotely by video evidence. We allow for that video evidence to be deemed such that the person is in the witness box, because the Evidence Act in clear terms says that you should be in a witness box to give evidence. And we allow for appearance further to be considered by further application. Here's where we go. We go for the 12AF, and we look to subclause 4. The court, in determining whether to allow an accused person to give evidence by video link, shall, in addition to the matters specified in subsections 2 and 3, take into account, and then we set out risk factors. The risk that the personal security of the particular person, including the accused, may be endangered. The risk of accused person escaping. The behavior of the accused person. The conduct of the accused person. Safety, welfare. These are all the circumstances as to why you would want to ensure that maximum security high-risk prisoners, as are in our courts right now, who when they come to Port of Spain or San Fernando have to shut down the entire city, blocking off streets, that we can treat with them by video link. This is of epic proportion to Trinidad and Tobago's advancement. But it is the new Section 12AG, Witness Anonymity Orders, where there are reasonable grounds to believe that the identity of a witness should be concealed from the accused person and the public so as to protect the witness and any of his relatives or other person, the court may grant a witness anonymity order. A party to criminal proceedings may, in relation to a witness, make an application to the court for a witness anonymity order.
Attorney General, you have 5 more
Thank you,
minutes.
Madam President. And before a court grants an order, as subsection 3 provides, the court shall consider whether the proposed order is necessary to protect the safety of the witness or another person, prevent serious damage to property, prevent real harm to the public interest. Having regard to circumstances, the effect of the order would be consistent to and with the accused person receiving a fair trial. And then we specifically ask the court to consider the general rights of the accused person in criminal proceedings to know the identity of the witness, to test credibility, to deal with whether evidence may be for another purpose, for implicating, etc., and fair. So this particular clause, 12AG, the proposed section 12AG, lifts from all the case law. It lifts from precedent law in other jurisdictions. It allows Trinidad and Tobago for the first time the opportunity to get witnesses to step forward, because a witness has a chance of saying, I will testify if I can be protected. But very importantly, we balance the rights of the accused to ensure that the accused has a fair shake. The accused lawyer, who has a balance to the court and to his client, that accused lawyer has the right to see who the person is, the judge, the jury, in certain circumstances. We're dealing with protection from the accused person. Now, a very important point. What about if this witness anonymity order is made and I object it? I want to appeal it. Something that I had a quick discussion before Parliament started on this. So, of course, there is an inherent appellate process route in our courts, but the criminal law has not grown up such that we have procedural appeals. And the introduction of a procedural appeal route is something that does not exist in other jurisdictions, because it would be akin to allowing a diversion and separation away from the fact that you take all of your massive points on appeal in the round. That's the way the criminal law operates right now. In fact, I dare say that an accused has a better chance in taking it in the round at the end of the trial in a substantive appeal, because that's the way the law is designed. There may be room for that discussion in another form of architecture, and that is whether it ought to be introduced in that conceptual basis, procedural appellate routes, as we have under the formula for civil proceedings rules. In the civil proceedings rules, it is there that we bifurcate what a procedural appeal looks like from a substantive appeal. It's not done in the parent law. So, Madam President, this law certainly has a legitimate aim. This law certainly has a careful intention to find proportionality by going no further than we really ought to. Yes, it does infringe or traverse some Section 4 and 5 rights. There has been ample commentary in umpteen cases, which I can easily recommend, but time does not permit. The point is, other jurisdictions certainly have this well into operation. In the case of the United Kingdom, even though the common law had gone there before, by virtue of parliamentary amendments from 2008 go forward, they have dealt with it. The rest of the Commonwealth has dealt with it. And our laws, as it relates to the 3/5 issues in the Children's Act, the Evidence Act, and we look to the Sexual Offences Act, we already have the utilization of protection via screens, etc. So our law has statutorily gone there already. So we fit within that last limb of Baroness Hale and Surratt or any one of the other cases that talk about constitutionality. Madam President, I look forward to the contributions of my learned colleagues. I welcome their suggestions. I know that this appears to be thick law. I've tried to give the simple purpose in as digestible a format as one can in 45 minutes, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Evidence Act, Chapter 702, be now read a second time. Senator Ramdeen.
Good afternoon, Madam President, again, and thank you for the opportunity, Madam President, to contribute to what I consider a very, very important and significant debate on an act to amend the Evidence Act, Chapter 702. Madam President, since this bill was laid on the order paper, the opposition has consulted with a number of practitioners from the criminal bar, a number of stakeholders who I will demonstrate are essential to the workings of this piece of legislation if it were to pass with the requisite majority. And I want to start my contribution today, Madam President, by thanking all of those persons who have assisted the opposition and who have provided very important, critical, relevant advice with respect to the reach of this particular piece of legislation. And I want to use that as the stepping stone to get into an issue that the Attorney General touched upon, which is the issue of consultation. The fact that the Attorney General indicated that there was consultation, the Attorney General's office received correspondence from the Trinidad and Tobago Police Service and the judiciary, but to date there has been no receipt of any submission from the criminal bar, the Director of Public Prosecution, or the Law Association. And that is disappointing, to say the least, Madam President. I myself, as a member of the Law Association, over the last few days, made inquiries of the Law Association as to whether and why, what was the position. I tried to get a copy of whatever would have been submitted to the Ministry of the Attorney General, and I can indicate that the position as indicated by the Attorney General is accurate. I understand that the Attorney General can advise me, and I will give way if he wishes, that the President of the Law Association has indicated that they wish an extension of time to put a submission before the Attorney General with respect to this particular piece of legislation. That is my understanding as a member of the Law Association.
The record before me, I don't have that particular point. Letter dated 13 September 2018, email 3rd October 2018 from us, acknowledged on the 3rd of the 10th 2018, email of the 12th October 2018, email and telephone conversations all coming from the AG's office, 25th of October 2018, and other positions. I have received nothing from the Law Association since September last year.
I'm obliged to you, Attorney General. But, Madam President, this is a piece of legislation that cannot work and will not work unless all of the players have all hands on deck. And I hear what the Attorney General has said, Madam President, but I too have my list here, and I would like to put those questions on the Hansard. The judiciary has been consulted. Was the magistracy consulted with respect to this submission by the judiciary? And I'll get into why that is important. The Justices of the Peace Association, there are 16 references to the work of the Justices of the Peace in this piece of legislation. I will highlight them to you as we go along. Have they been consulted? There's an association called the Justices of the Peace Association, you know. Let us at least give them the respect where they have to perform a critical safeguarding the interests of the accused under this piece of legislation. Can we at least give them the respect to consult them, to ask them whether they are ready to perform the function that they have to perform under this piece of legislation? I repeat, there are 16 references to them in these amendments that have been produced. Madam President, this piece of legislation is driven, or has to be, or is foreseen to be driven by the Office of the Director of Public Prosecution. The engine room of the prosecutorial process under our law, by virtue of Section 90 of the Constitution, is driven by the Office of the Director of Public Prosecution. I don't think, Madam President, any piece of legislation that requires such an important institution to drive the legislation, that we could ever sit here comfortably knowing that we have not had, and let me say we, but let me say the government, the cabinet, has not had the views of the Director of Public Prosecution in relation to this particular piece of legislation. It is entirely, I'm not laying any blame, Madam President. I'm just saying what the position is to be. You see, Madam President, on more than one occasion in this Senate, I've heard it said, rightfully so, it's an adage that has withstood the test of time, that perfection is the enemy of progress. And I've sat down and preparing for this debate and wondered about this thing. Perfection is the enemy of progress. But not getting it right is the enemy of both perfection and progress. And we can't get it right unless the person who is in charge of telling us will this do what we want it to do? The Attorney General says the most important issue as a country for us to confront is the issue of crime and criminality. But, Madam President, that is not something that popped up yesterday. The government has been in power for the last, this is going into their 4th year. And one would have thought that when you promised the country safety and security in 2015, that at least by 2019, the country would have said they are a little bit safer or a little bit more secure. But the truth about it is, when you talk to the common citizen who has to go to work and send their children to school and return home on a daily basis, wherever you are, from Scarborough to Icacas to Grandy to Point Fortin to Guayari, the position is nobody feels safer today and nobody is more secure. And it is not open to the government to be able to lay that blame anywhere else. Because, yes, you have a Trinidad and Tobago police service that has to protect and serve, but the responsibility to protect the citizens of this country lies with the government of Trinidad and Tobago. There's no getting away from that. Now, Mr. Vice President, I apologize. Mr. Vice President, I want to get into a very, very important issue for me. The Attorney General says there are 5 divisions in this piece of legislation. 6, sorry, apologize. 6. The way set out in the legislation is 5. It's Division 1, 2, 3, 4, and 5. There's no Division 6. But that's just the way it's set out. I am guided. But this is the position. This piece of legislation, whether it be identification parade, oral confessions, witness anonymity, all of these things, who has to implement this? Who has to implement this? Let's leave the prosecution aside for the time being. It's the judiciary. And we will be burying our heads deeply in the sands, which I am not prepared to do, to not analyze whether we are not putting the cart before the horse, where at this point in time, you bring a piece of legislation that vests for the first time very, very serious powers into the hands of the judiciary. And when I say the judiciary, I mean collectively the magistracy, the masters, the high court judges. And can we honestly sit here and put our heads into the sand and not realize that at this point in time, the judiciary that has to implement these powers that are being given by this piece of legislation is broken? It is at the darkest point in the history of our country. And let me give you the real examples of that, Mr. Vice President. For the last 2 Mondays, and the Monday and Tuesday last week, and Monday this week, right? What you have going on the steps of the Hall of Justice is that the workers of the Hall of Justice, who have to put their shoulders to the wheel every day, are praying for justice for the first time in this country. And we can bring all the legislation we want, Mr. Vice President. We could bring all the amendments to the Evidence Act, to the Police Service Act. You could bring judge alone, right? Plea bargaining. At the end of the day, all of this that the government puts before us is not going to work unless we get the judiciary working again. And that is the motto of the opposition. We, as an opposition, readying to take up the reins of power in this country, will put the judiciary as a priority on our agenda. And Mr. Vice President, is not the opposition talking? Because I have a message there on my phone. I don't want to read it into the Hansard as yet. Something I read last night about a statement by the Prime Minister, but I'll get to that in a short while. Let me tell you where we have reached. It's so ironic that today I pick up the Newsday newspaper, and the headline is, Judge versus Court Executive. Mr. Vice President. Mr. Vice President, you may not have the benefit of it, but for those who occupy the seats in this chamber that have to go to work every day in the courts of this country, we understand that when you speak about the powers that are given to the judiciary here, these powers that are given under these 5 divisions of this particular piece of legislation, it can't work without the court staff, you know. A court doesn't incorporate itself with a judge alone, you know. A judge works with the staff, and the justice cannot be dispensed in this country without those people who come to court every day, give of their lives, leave their families at home. And today, those people's lives, their livelihood is at risk because of things that have been done right here. Because in the Criminal Division Bill, which has been passed, I stood up right here and I told the Senate that the powers that were going to be given to the court executive administrator in that piece of legislation were going to bring the judiciary down. And so said, so done. Unfortunately, that has come to pass. And today, Madam President, sorry, Mr. Vice President, sorry. Today, Mr. Vice President, in the Newsday headline, you have a judge of the High Court, not only a judge, a senior judge of the High Court, indicating, can't read out all of it, Mr. Vice President, indicating, right, that the court executive administrator must know her place and respect the judges of the High Court. How could that be? How could we reach to that point? Don't we expect that this piece of legislation, the amendments to the Evidence Act, don't we understand that this can only work, right, if the judges are given the support? We talk about giving support to the TTPS. We talk about giving support to the Director of Public Prosecution. What about the support to the judiciary? Who has to get this done? Mr. Vice President, let me read 2 sentences. Let me read 2 sentences to tell you where we are. In a strongly worded email, Justice Carol Gobin took offense to the tone used by the court executive administrator, Master Christiane Morris Allen, in response to her request for a meeting to discuss changes in the judiciary. And this all stems from what we are doing here, you know. Because when you go on in the article, Mr. Vice President, you will see that this is all part of the government's criminal justice reform that this piece of legislation is supposed to be a critical part of. So, Mr. Vice President, before we get off the ground with this piece of legislation, I want to indicate this opposition will stand with every single worker of the judiciary whose livelihood and job is at threat right now. And this opposition will do all in its power to prevent any officer in any part of the state that seeks to exercise powers to the detriment of any citizen of this country. So let me put that to one side. Right now, I indicated that the Director of Public Prosecution's office is the driver under this piece of legislation. You know where we are at the administration of justice, Mr. Vice President? The 2 significant movers in the administration of justice in this country, the Attorney General's office, the Director of Public Prosecution. Section 76 of the Constitution vests that power in the Attorney General. Section 90 of the Constitution vests that power in the Director of Public Prosecution. Mr. Vice President, do you know where we are right now? Where we are talking about moving the criminal justice system along, right? This is where we are physically. Let's come to reality. The Director of Public Prosecution doesn't have a proper office to run his office from. So he is going to rent a building on Park Street, $500,000 a month. The Attorney General has just been boxed out of Cabildo Chambers, and he coming down to Tower C. So the two most important drivers in the justice system in Trinidad, they're virtually squatting in Port-au-Spain. Squatting.
May I ask that you finesse
sorry,
language
Madam
a little
President.
bit,
Right.
okay?
Okay. They're wanting for accommodation in Port-au-Spain, Madam President. And, Madam President, that's not a simple thing to deal with, you know, because we have been told in this Parliament that the Director of Public Prosecution will get his office at Gulf City Mall for more than 2 years. It's 2 years we've been saying that. We've been being told that. And as we speak today, that didn't materialize as yet. The Attorney General said in his contribution, there are 165, write it down here, there are 165,000 cases in the magistrate court. But you know what is shocking about that, Madam President? 2 years ago, on the 27th of July, 2017, we were told that the Motor Vehicle and Road Traffic Amendment will take 100,000 cases out of the magistrate court. Well, we're still waiting on that 100,000 cases. That was proclaimed. Sorry, that was assented to, not yet proclaimed. So in 2017, we were told that. The Chief Justice did his annual opening of the law term. We heard 100,000 will be removed. This year, we will hear it again. 100,000 will be removed, and nothing is happening. Nothing has happened with respect to taking those 100,000 cases. So you know what, Madam President? One has to ask themselves, is this piece of legislation, just like how the promised relief that was promised under the Motor Vehicle and Road Traffic Amendment, when that was promised that the 100,000 cases will come out, you are adding, we are told 30,000 cases every year, you know. How is this going to affect that? How is this going to better the situation at the magistracy? Right now, this piece of legislation has to be implemented in our magistrate court in San Fernando, the second city in this country, where there is no magistrate court. They're borrowing accommodation at the High Court. And that is going on, honky-dory, right? Court like Junior Sec, sitting on shift, 9 to 12, 12 to 4. I mean, don't we think that we should put the horse first and fix the things that are broken now? Give the institutions that need the resources to get this working, the resources that they need, so that when the legislation is passed, if it is passed, we can be comfortable or comforted by the fact that the institutions that are supposed to be supposed to be the drivers of this piece of legislation will be ready, willing, and most of all, able to get the job done. Because, Madam President, all we're doing here, with all the laudable aims that the Attorney General has set out, right, is just spinning top in mud, you know. That is all we are doing here. And I say so respectfully, Madam President. Madam President, the Attorney General in his contribution on 3 occasions made reference to the Witness Protection Program. I want to remind this country that during the 1990s, between 1995 and 2000, you know, we didn't have, like the Attorney General said, we didn't have any witness anonymity order. We didn't have any amendments to the Evidence Act. We didn't have video link. We didn't have CCTV. But you know what we did have, Madam President? We had the most dangerous situation when it came to witnesses between the year 1995 to 2000. We had this situation where once an accused, certain people accused, were before the court, all of a sudden the witnesses would drop like flies and prosecutions would crumble. But you know what we had during 1995 and 2000? We had a government that was serious about the fight against crime. We had a UNC government and a UNC Attorney General that didn't need all of this to bring up prosecution of the person that was referred to in this country as the gangland boss. And when Levi Morris came to give evidence in that matter, he didn't do it by video link. He didn't come and have a video recording. He didn't say, I would do it only, I am in fear. The most dangerous group of people were existing at that time in this country. And that organization was brought down by a government that was serious about the fight against crime. So, the truth about it is, Madam President, the reality of it is this. You could pass all the legislation you want, but if you are not serious about getting that legislation working, all of this will amount to nothing. And this opposition in government has proven by their track record that they were ready, willing, able, and competent to be able to put machinery in place to fight the criminal element, did fight the criminal element, and got rid of the most dangerous group of people without any legislation like this. And you know why I say that, Madam President? Because we have heard over and over in this parliament and in the parliament before that, when the last government brought legislation in two forms, perhaps two of the most critical pieces of legislation to fight crime, the Constitutional Amendment Bill to allow people to hang those people who were convicted of crime in this country. You know what the then opposition, right, who boasts about supporting 95% of legislation by a People's Partnership government did? They say, go and ask Ramesh how to do that. We are supporting that. Yes. Right? That's what they said to the government. Progressive legislation to categorize murders. They said, go and ask Ramesh how to do that. Go and do your work. Right? And if you do your work, you will be able to solve crime in this country. Go and set up a proper witness protection program. This issue, you know, we come here and we icing the cake about this thing about witness anonymity. Perhaps the most pervasive intrusion into the rights of an accused, and I will get into that, let me get into that now, Madam President. I heard the Attorney General say that in the United Kingdom, the courts, up to the House of Lords, said, this is not a matter for the courts, this is a matter for the Parliament. You know why, even though the Attorney General explained that was the position taken in the House of Lords in Davies, I don't think he went further than that to explain that the reason why that was so, according to the House of Lords, was because the Parliament is the voice of the people. And what we are undertaking here is perhaps one of the most serious debates of one of the most serious intrusions into the fundamental cause of the criminal justice system. Because what we are doing here, if it is passed, will allow persons to intrude into the rights, the fundamental rights of that criminal justice process, Madam President. Madam President, the Attorney General cited two sections of Section 5 of the Constitution and indicated that, yes, these are the sections that require the special majority provisions under Section 13 because they would be breached. Let me just add to that. This piece of legislation will, if passed, intrude upon the right under Section 4A, the right of the individual to life, liberty, security of the person, enjoyment of property, and the right not to be deprived thereof except by due process. It will intrude on the right of the individual to the equality before the law and the protection of the law. And not very often, Madam President, that it is said, that that 4B right is really a right that guarantees the equality of arms under the Constitution. And this bill, especially Division 4 and Division 5, has the potential to intrude on that right to the equality of arms between the accused and the state. This piece of legislation, Madam President, will intrude on Section 5.2c, Section 52D, Section 52F, Section 52E, and Section 52H of the Constitution. And I expected that the Attorney General would, in piloting of this piece of legislation, would have told us, well, if these rights are going to be infringed, as they are presumed to be, where a Section 13 majority, 3/5 majority is required, I thought the Attorney General would have gone a little bit further and explained to the Senate exactly how the safeguards will be secured. And I heard him say it pursues a legitimate aim and it is proportionate. But there's a serious issue with this piece of legislation, different from all the others, you know, Madam Vice President, and it is this. Madam President, that it is this. Before independence in 1962, we subscribed as a colony to the European Convention on Human Rights. That convention would have, in 1962, would have been merged into the constitutional rights that would have existed at that point in time. And this is not Ramdeen expatiating, Madam Vice President. This was recognized by the Privy Council in Res and the Queen, a very distinguished judgment that was delivered by Lord Bingham in striking down the death penalty provisions in Belize. And there's an important consequence of that, which is that we, those that study public law and constitutional law, recognize that the rights that are enshrined under Section 4 and 5 are recognized as being qualified rights. But in preparing for this particular debate, Madam President, it is very clear that that general provision, that these rights that are guaranteed under fundamental human rights provisions of our Constitution are qualified, does not apply to the right to a fair trial. The right to a fair trial is not a qualified right. And let me just put on the record that the authority for that proposition, Madam President, is the case of R versus A, 2001 UK House of Lords. And in the speech of a very distinguished Lord Hope, this is what Lord Hope had to say. The right of an accused under Article 6.1, that is the same mirror image with some changes that I will get to, of our fundamental rights provision under Section 4A and B that are fleshed out in Section 5.2. The right of an accused under Article 6.1 of the Convention is to a fair trial. As I observed, that is Lord Hope, as I observed in Brown versus Scott, this is a fundamental and absolute right. It is a fundamental and absolute right. The only two rights that are guaranteed in any human rights document throughout the Commonwealth and throughout the world that are recognized to be absolute rights are the right to a fair trial and the prohibition against torture. And therefore, when you come to interfere with those rights, Madam President, the issue of proportionality doesn't arise at all. It may pursue a legitimate aim, but you see that issue in Surat about whether it is proportionate, it doesn't arise in this particular case because it is an absolute right. You have no permission to intrude on that right. And the case of Davies that the Honorable Attorney General made reference to is a very, very, very important case because I want to just be able to read into the answer this, Madam President. In that case, a case where two murderers were challenging the issue of an anonymous witness giving evidence in their matter. This is what the House of Lords had to say. It was a long-established principle of the English common law that the defendant in a criminal trial should be confronted by his accusers in order that he might cross-examine him and challenge the evidence. That principle was subject to some long-recognized exceptions and statutory qualifications, but there had been, until recently, no precedent of protective measures of the kind under consideration. In that case, Madam Vice, unquote, in that case, this is what the House of Lords had to say. Moreover, the use of protective measures, which is exactly what we are dealing with here today, such as those in the instant case, was not compatible with the jurisprudence of the Strasbourg Court. In the instant case, the impact of the protective measures on the conduct of the defense meant that it had been hampered in a manner and to an extent which had been unlawful and had rendered the trial unfair. It was not open to the House in its judicial capacity to make such far-reaching inroads into the common law rights of a defendant as would be involved in endorsing the procedure adopted in this first case. And the Attorney General is right in saying any further relaxation of the basic common law rule was for Parliament. There was nothing in Strasbourg jurisprudence that required states in their national law to balance anonymity against defendants' rights. Madam President, it is often said, and it was also said in this R versus A case by Lord Johann Stein, that there is a triangulation of rights when it comes to this type of legislation. You have the right of the society, which is represented by the public interest, the right of the complainant, the victim, and the right of the accused. And as a parliament, we must be very careful and we must be very cautious when legislation is brought to our parliament to intrude on these rights that will allow, Madam President, someone to come before a court and give evidence without their identity being known, without their voice being known, without full and frank disclosure being given. And that person can be the critical witness that lies between a man and his life going to the gallows. And we must understand the seriousness of the task that we have been given to undertake here today, because it is not an easy task that we must take lightly, that what we are being called upon today is to overturn, override, and intrude what has been the common law of our country from time immemorial. And you know why it is dangerous, Madam President? Legislation like this is dangerous, and it is more dangerous where a society is desperate for relief from the criminal element. Because in those times, you are easily persuaded to give up those rights that are guaranteed to you on the basis that relief will be brought to you if this type of legislation is passed. It is easy to stand up and to say, make anonymity orders, make special measure division orders to facilitate the prosecution. Madam President, do you think that it is right for us to overhaul the standing orders of the police service by Division 2 of this particular piece of legislation? Put all of these measures in place that's supposed to guarantee that when identification evidence is brought before the court, it will be untainted and it will be able to secure prosecutions. When we can't guarantee to ourselves that the people who are supposed to implement this, being the Trinidad and Tobago Police Service, will be free from being corrupt and corrupt the system when that evidence is brought before the court. Because every single day, Madam Vice President, the two first divisions of this, the second and third division of this piece of legislation, the identification, and the other members of the opposition will go into great detail on it. The identification evidence and the oral confessions and oral admissions are not the reasons why people are prosecuted in this country, you know. They are the reasons why people are not prosecuted and prosecutions fail in this country. And what have we been told as a parliament that is being put in place to ensure that this piece of legislation, if passed, is going to guarantee a process that is untainted? What have we been told with respect to the training of the police officers who have to implement the oral confessions provisions and the identification provisions that are found in Division 2 and Division 3? We've been told nothing. So when the legislation is passed, there is no guarantee that anything in the Trinidad and Tobago Police Service is going to change. Every single day we open a newspaper and you see one corrupt police officer after another police officer before the court. Doesn't that cause us some concern? Madam President, this piece of legislation, and I say so respectfully, the Attorney General said the precedent for this in the United Kingdom and throughout the Commonwealth has been since 2008, 2009, right? This has been on the law books in other jurisdictions. Have we been told what is the difference it has made to prosecutions in those jurisdictions where this has been implemented? Not that that is going to be a mirror image of what is going to happen here. But if this doesn't work...
Senator Ramdeen, you have 5 minutes.
I'm obliged, Madam President. If this doesn't work in a United Kingdom where the police service there, right, has all of the mechanisms and all of the resources to get it right in implementing this, you expect it to work here in Trinidad and Tobago? Really? Madam President, I want to say to the government, it's not because you see it in the United Kingdom. You know, I've heard them say in the debates that one of the, they refer to one of the investments that the last government made as the Prime Minister went to China and said, we want one of that, and they bring it here. Well, I can tell you, you know what this government has done? They look to the United Kingdom and say, we want some of that, and we bring it here in a piece of legislation. Absolutely, absolutely. No proper foundation, no institutional foundation, nothing has been put in place. But it sounds good there, so bring it here, we can sell it to the population, pass it, and you know what will be the result of that, Madam President? When it's passed and it doesn't work, it'll be like the anti-gang. Don't blame we, you know. That's the police.
Yeah, blame the police.
Right? We do our part. We pass the law. Right? Don't forget that this piece of legislation is to be driven by the Trinidad and Tobago Police Service. Right? And a week ago, the Trinidad and Tobago Police Service is telling us they don't even have money to pay their bills.
Or feed the dogs.
So let's get serious, Madam President. This opposition has demonstrated by its actions. We are prepared to support legislation that strikes the right balance between the citizen and the state. We are prepared to support legislation that is in the best interest of the people of Trinidad and Tobago. But we are not prepared to put laws on the law books of this country that will be to the detriment of any citizen, that will erode the fair trial rights of any accused, because it is very easy to prescribe these types of laws. The difficulty with it is that I heard the Attorney General say, don't worry about procedural appeals in criminal matters. The best thing to do is take it at the end. So you know what will happen with that? A man who must face a capital charge must sit down in the dock, hear the evidence, listen, don't see, hear somebody who he don't know give evidence against him. Let the death warrant be read to him. Let him go up in the gallows. And I was before the Court of Appeal this morning in a matter where the Court of Appeal was telling a man who is sitting in the gallows for the last 7 years, wait 2 more months for the notes now, because we are ready to do your appeal yet. The notes are ready. Right? 7 years in the...
You know the rules.
I'm obliged, Madam President. I apologize. All I'm saying, Madam President, is that is an example of a broken system. It is a system that the voiceless cannot voice the suffering that they are suffering with. And this is a bill that will put more suffering and more hardship on the poor people who cannot get justice in this country. And this is not going to make the situation any easier than that. And as it stands now, I want to close by saying, you will not have the support of the opposition to engage in that. I thank you, Madam President.
Thank you, Madam President, for the opportunity to contribute to the debate on the Evidence Amendment Bill. Madam President, the proposed amendments are to ensure that the evidence is gathered using modern and technologically driven methods. We've seen too many cases fall apart because of the inadequacy of the methods now used in collecting and presenting evidence. Also, witnesses give statements to the police, and when they go back to their homes, they are threatened or even bribed. At the trials, witnesses say they can't remember, they forgot, they lied, they had amnesia. And there are many other reasons. This did not happen, I'm suffering or whatever. Therefore, we need to have ways of capturing irrefutable evidence from witnesses as close as possible to the time of the incident. Madam President, we've heard on numerous occasions of evidence being tampered with, eaten by rats, gone missing. So amnesia and willful neglect exacerbate the issue. Therefore, I have no reservation in endorsing the upgrading and modernizing of the evidence gathering and presenting processes as identified in the bill. However, I do wish to caution that every electronic system can be tampered with or manipulated, either accidentally or intentionally, from both internal and external sources. Time and time again, we hear fake news where video, audio, or other electronic material are changed on social media and other places. Therefore, it is imperative that the integrity of the devices and systems are such that only usable and irrefutable evidence is collected, secured, and presented to the courts. Only in this way will perpetrators of crime face the consequences of their actions with increasing successful convictions. Thank you, Madam President.
Ms. Simonette.
Madam President, thank you for the opportunity to make a contribution to this very important bill aimed at amending the Evidence Act, Chapter 702. Madam President, it is important for the listening population to understand in rather simple manner what is before this Honorable Senate today. And I wish to start with a position put by my learned friend, Mr. Ramdeen, or Senator Ramdeen, regarding the common law and the role and function of Parliament. The Honorable Attorney General of the government, of which I quite proudly am a member, has been seeking for some time to improve and amend the legal provisions relative to treating with and dealing with the issue of crime. Fundamental to a respect for the law by all concerned is a recognition that those who commit crime are answerable, that there are mechanisms to bring them to answer and to justice, and that is done within a reasonable period of time, of course, adhering to all the dictates of the protections of the Constitution to a fair trial, a fair hearing, and the right to counsel, etc. Clearly, where you look at the regime of criminal justice and criminal law with regard to the conduct of criminal trials, there is the requirement on the part of the prosecution to adduce evidence to substantiate the charges that the accused is asked to answer. That evidence is produced in many forms. It can be produced orally, it can be produced in documents. But for far too long, the status of adducing evidence in criminal trials has remained unaddressed, and the Attorney General shared with the country the length of time that this has been in a state of anachronistic paralysis. Now, when we intervene as a parliament, we are not intervening in any contravention of balance between parliament, the courts, the common law, etc. As Senator Ramdeen ought to know from elementary tenets of law, the highest court of the land is the parliament. I repeat, the highest court of our republic is this Parliament. And that is why the House of Lords in Davis deferred to Parliament to intervene in changing what was well-settled, long-standing common law with regard to the status and exposure of vulnerable witnesses and the old and tested regime of permitting an accused full access to the identity and all that an accuser or a witness was saying against him or her, and the opportunity to cross-examine such a witness. And this is precisely what this Parliament is now being asked to do. Intervene in the area of creating a regime for bringing into being evidence being led and evidence being adduced in one area, which is the area of witness anonymity that Senator Ramdeen chose to focus on as being fundamental in depriving the accused of his right or her right to a fair trial. We are not engaging in any travesty of either the courts or the common law. We are simply doing the job that the people have put us here to do. And we are doing that, if I dare say, with particular distinction, attention to detail, and balancing of the interest of the accused against the interest of the victims and against the wider public interest in seeing that our criminal justice system begins to address the delivery of proper criminal justice. One of the other issues I would like to dispose of before going into the framework of the bill, and what I hope to demonstrate to be the balanced proportionality of the bill in being very careful to ensure that the procedures in these areas of taking new evidence carefully permit for the accused to have access to all relevant information along each step of the way. I wish to dispose of, Madam President, the statement made by my learned friend Senator Ramdeen that this bill fundamentally intrudes upon and trammels sections 4 and 5 of the Constitution. And it was a very deft submission Senator Ramdeen made without going into the particulars of what he was referring to. Section 4 and 5 of the Constitution, as those of us who are familiar with the Constitution know, create the enshrined rights and fundamental human rights and freedoms that have been in existence since 1962, and since the reception of such rights flowing from the creation of the internationally recognized human rights and privileges held dear and established following the travesty of the Second World War. Section 4A of the Constitution, and I read, says as follows: "It is hereby recognized and declared that in Trinidad and Tobago there have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex, the following fundamental human rights and freedoms, namely: A, the right of the individual to life, liberty, security of the person, and enjoyment of property, and the right to be not to be deprived thereof, except by due process of law. Senator Ramdeen submitted that that right was trammeled by this bill. He did not condescend to indicate or to point to which sections of the bill so contravened that right. And Madam President, I would like to suggest quite firmly that no such contravention of Section 4A exists in this bill. Section 4B indicates the right of the individual to equality before the law and the protection of the law. My learned friend Senator Ramdeen tried to indicate that by creating witness anonymity provisions, that in some way the right to equality before the law and protection of the law was trammeled. That is, the deprivation of the right of an accused to face his accuser stroke witness fully and frontally in a trial to which he is entitled to counsel of his choice. As will be seen from the witness anonymity provisions, which place that regulation in the hands of the judge, there is a balancing procedure for the accused counsel to test and to put questions to the witness whose anonymity is shrouded or veiled. It is not that the accused is deprived of any access to the anonymous witness. The identity of the witness, the face of the witness, the voice of the witness, to some extent, is indeed shrouded or shielded from the otherwise full view of the accused, as would ordinarily be the case where the witness is put into the box and the accused or his counsel is free to cross-examine, etc. There is no absolute bar in the provisions, as we will see when we come to the details of the provisions, Madam President, to the accused having access to putting questions to the witness whose full identity is not exposed for certain reasons as set out in the Act, and which the judge must first consider very carefully before making a witness anonymity order. So it is not that this is imposed on an accused by the flick of a switch. There's a process under judicial management which must carefully be reviewed before such an order is made. When the order is made, there still is provision for the accused representative to put questions to the witness whose anonymity is being shrouded. Senator Ramdeen then indicated that the provisions of the bill will contravene sections 5, and he went into detail, sections 5(2), C, D, F, and H. And I think it is important to look at C, D, F, and H of Section 5 of the Constitution. Section 5 says, and I read, Madam President, except as otherwise expressly provided in this chapter and in Section 54, no law may abrogate, abridge, or infringe, or authorize the abrogation, abridgment, or infringement of any of the rights and freedoms hereinbefore recognized and declared. And 5(2) says, without prejudice to subsection 1, but subject to this chapter and to Section 54, Parliament may not, C, deprive a person who has been arrested or detained, 1, of the right to be informed promptly and with sufficient particularity of the reason for his arrest or detention. Now, for crying out loud, where in this bill is that right abrogated? That the accused is not, the arrested person is not informed promptly or with sufficient particularity of the reason for his arrest or detention. Just simply does not exist, Madam President. Section 5(2)(d). Authorize a court, tribunal, commission, board, or other authority to compel a person to give evidence unless he is afforded protection against self-incrimination and, where necessary, to ensure such protection, the right to legal representation. Now, it very clearly is stated in the provisions in the bill that wheresoever an accused person does not consent to certain things, he may elect to do so, and that consent is, that election is recorded in documents that are then made available to the process, so that there is no compulsion by any court or tribunal compelling any person to contravene or incriminate himself or herself in this bill. Senator Ramdeen has not pointed to any such provision. So that submission is, with respect, incorrect, to say the least. At 5(2)(f), no person shall be, no law or parliament shall pass no law to deprive a person charged with a criminal offense of the right, one, to be presumed innocent until proven guilty, according to law. But this shall not invalidate a law by reason only that the law imposes on any such person the burden of proving particular facts. 2, to a fair and public hearing by an independent and impartial tribunal. Or 3, to reasonable bail without cause. Where does this bill contravene any of those provisions? Where does the bill, Madam President, I put it, contravene any provision of Section 5(f)? Section 5(h), deprive a person of the right to such procedural provisions as are necessary for the purpose of giving effect and protection to the aforesaid rights and freedoms. And that perhaps is where we find the requirement to have a special majority for the bill, and that is in the limitation to the old common law of having full access to the witness who stands as the accuser or witness who stands in support of giving evidence in support of the facts leading to a conviction of an accused. And that requires, Madam President, a review of what those provisions indicate to assess whether indeed there is a degree of balancing and there is a degree of fairness in the provisions. If I may go to that provision, Madam President, which is Division 5. I do apologize, Madam President. It's Division 4, the special measures, evidence of video link, and witness anonymity orders. Madam President, the first observation is that new Section 12AA1 provides for an application by anyone, any party in the proceedings for a special measure or a combination of special measures, of course, which includes a witness anonymity order. Before the court and the regulation of this new procedure is put squarely in the hands of the judicial officer, being the judge, and before the judge is embarks on an exercise to consider this, she must consider or be satisfied that the witness is a vulnerable witness. The quality of the evidence given by the witness is likely to be diminished by reason of fear or distress on the part of the witness in connection with testifying in the proceedings, and that the purpose, the vulnerable witness definition means, and is given, and the Attorney General shared that with us, I will not go into it again. The court may also consider it appropriate to protect the identity of a witness from the public or protect the witness from being intimidated by the presence of other persons in the courtroom, issue a special measure direction that the proceedings be enclosed and be in a closed environment as opposed to an open court, so that that would otherwise contravene, as it were, 5H, where the criminal trial is normally in, of course, open court. Where the court considers it appropriate, the court may issue a special measure order. In relation to the witness anonymity aspect of it, the court is required to satisfy itself, Madam President, that the risk that the personal security of a particular person, including the accused, may be endangered if the accused person appears in open court. The court also goes on to consider the risk of the accused person escaping or attempting to escape. So, my apologies, Madam President. Madam President, the provision Yes, I do apologize, Madam President. In considering the witness anonymity order, the court would consider that the order is necessary to protect the safety of the witness or another person, to prevent any serious damage to property, or to prevent real harm to the public interest. Where the court has considered those issues, Madam President, then the court has, again, to balance that having regard to all the circumstances, the effect of the proposed order would be consistent with the accused person receiving a fair trial. So that the question of whether the witness anonymity order ultimately is against the fairness of the trial of the accused and the accused's entitlement under the Constitution to a fair trial is a matter that the judge, by the provisional requirement of the bill to become the act, will ultimately exercise a weighing exercise to ensure that such an order did not affect the fair trial of the accused. But what it does indeed do, Madam President, is provide a modern regime for permitting otherwise vulnerable witnesses important to the administration of criminal justice to come forward without the fear that they would disappear or be harassed or their families disappear or harassed. And interestingly, my learned friend Senator Ramdeen could point to no better flag of achievement than that of former Attorney General Ramesh Lawrence Maharaj in the Dole Chedi case in the 1995 to 2000 period of a former UNC government. What he has not been able to point to was any similar success in the subsequent PP government's term, 2010 to 2015. Nor could he point to any because none exist. And dare I say, Madam President, that the success in the Dole Chedi case is of no application to what has transpired in this country since the early 2000s with regard to the escalation of tampering with prosecution witnesses, the disappearance of prosecution witnesses, and the overall domination of the administration of criminal justice by elements who are convinced and rooted in criminal activity. Madam President, the other area of this bill, the other areas of this bill, which seek to bring the administration of criminal justice and the ease of taking evidence into the modern era, is the use, of course, of video link recording. Madam President, I practice principally in the civil commercial arena, and I can say that I have the distinction of having participated in the first civil video link taking of evidence in a case. It's not an ongoing case, it's a decided case. I will not cite the case, but the learned judge was Justice Budu Singh. And interestingly, we were taking evidence of a ship captain located in Ukraine by video link. It was extremely useful, it was extremely efficient, and the court was able to administer the proceedings without glitch. And that was in the High Court of Justice. So that I can attest to the savings that would be achieved in establishing the taking of video link evidence from the remand yard on the one hand, and on the other hand, the ability to take video link evidence from witnesses who may not be in Trinidad and Tobago, who may not be proximate to the court hearing the matter under trial. The taking of oral evidence of admission is also, and the admissibility into evidence of such admissions, regulated as it is by this bill, is also, Madam President, of interest. Again, the provisions on that create a proportionate approach to fairness, where the statements taken of the admissions are to be handed to the accused person and to his representative, counsel, attorney at law, etc. Madam President, the interesting other feature in terms of the modernization of the legislation and its facilitating of technology is the provision treating with the CCT camera evidence created in Division Number 5, where very simply but effectively the provision states, a video recording recorded by means of a closed-circuit television camera shall be admissible as evidence. Now, Madam President, much light, dismissive comments have been made about traffic offenses and the clogging up of the magistrate's court by traffic offenses. This provision, as it relates to traffic offenses, will in fact be of very, very telling importance. As we are aware, there is always a view taken by one driver as opposed to another as to what was done and what had occurred in an accident, between a vehicular accident. The admission and admissibility of CCTV evidence will put a lot of that time wasting out of the equation of resolving these otherwise simple traffic accidents and accidents that possibly not so simple, but where the liability for the accident ought not to become the subject of some protracted procedure and court deliberation where the establishment of the wrong party can be achieved by reference to a contemporaneous recording of what occurred at the accident. So that I think that that provision of its own, 12AI of the Division 5, would, in the area of road traffic accidents, have of extremely important value. It also is of value, Madam President, in relation to the recording of other criminal activity. And it cannot be dismissed simply by saying, oh, we are promoting a society in which Big Brother is watching you. I think that the entire modern world is moving towards the imposition of CCTVs in public places aimed at increasing the safety of the general community and providing for the creation of this very type of quality material that will assist in the implementation of criminal prosecutions where otherwise such prosecutions would be unassisted by modern technology. Madam President, the taking of the evidence, just going back to one other provision before going to the other special provisions, by video link in relation to evidence taken at the remand yard will, in a very meaningful way, save the taxpayer considerable sums of money in prisoner transportation, which, of course, such savings can be used to attend to the very issues that Senator Ramdeen was pointing out as to court facilities in need of upgrade and so on. The other provisions in the bill, Madam President, on special provisions regarding assistance to vulnerable or otherwise disabled witnesses is to be welcomed. And those appear at Division 5, in summary, Madam, the provision of, again, technology to assist those who are disabled, and that is to be welcomed, Madam President. Madam President,
Senator Simonette, you have 5 more minutes.
Madam President, if I may close by, thank you, Madam President. If I may close by treating with the thrust of Senator Ramdeen's admonition to this Parliament. Do nothing because the police are not trained. Do nothing because the judiciary's court executive and a learned judge have argued over an issue. Do nothing because the laws in other places that have done this, you have not shown us whether it has worked. Do nothing because you first need to address the improvement to the conditions of court staff. Now, Madam President, it is a repeated admonition of Senator Ramdeen's and of the opposition, if I dare say so. And that is a repeated admonition that this country should rightly reject, because it does not at all in any way amount to a credible reason for not looking into the appropriate mechanisms for improving our criminal justice system. Madam President, the do-nothing position is the standard position of the opposition. Do nothing, say nothing, and accordingly, at the end of the day, they will say that we have done nothing. So that if we were to listen to that, the country would indeed be at standstill. We will not listen to it, we reject it, and we will continue to act maturely, soberly, and properly in the interest of the citizens of Trinidad and Tobago. Thank you, Madam President.
Honourable Senators, we will now suspend for the break, and we will return at 5 p.m. When we do, Senator Hussain will begin his presentation. So we are suspended until 5 p.m.